Hello, I'm going to take you through AC 1.1 of Unit 4, which is the legislative process. Now, when we're talking about the legislative process, what we're talking about here is how laws in the United Kingdom are made, the process by which something comes from an idea into becoming into a law, also known as an act. Now, in order to understand the legislative process, you need to be familiar with how our government, our parliament, is made up. So you should be familiar from TV when you look at the House of Commons, the green seats, that's where our elected MPs sit. So if you think about the House of Commons, we've got 650 members who are known as members of Parliament, and they represent a constituency, and that member of Parliament is elected at a general election, which in general are held every 5 years. So your MP that you elect when you're 18 for your constituency in Plymouth, so I believe near Plymouth it's Gary Streeter, he stands for election, he is elected, whatever party he represents, he will fight for your local rights within the government. Whoever has the most MPs, in other words a majority, the leader of that party becomes the Prime Minister, they form a cabinet, and then the losing parties form the opposition. So the first question I would ask of you is, do you fully understand what the difference is between Parliament and government? Now the answer to that is, Parliament refers to all of those MPs, so that could be from any party, that could be Liberal Democrat, Conservative, Labour, Welsh Nationalist, Plaid Cymru, Scottish Nationalists, whatever. Government are the party that is elected in power with majority. So at the time of recording this PowerPoint in 2020, that's the Prime Minister is Boris Johnson, who leads the Tory party, also known as the Conservatives, and they are the government of this country. The role of the House of Commons is really clear. They're directly elected, and it is them that make policy and decide how to run the country. So they would debate matters of current concern, they'd scrutinise and vote on whether to approve laws proposed by the government. And also MPs will challenge the government in order to hold it to account. And that involves rigorous questioning. And you might see this when you look at Prime Minister's question times, when the leader of the opposition will take the Prime Minister to task about what he's doing at the moment. And of course the key thing is that the MPs are there to represent your views. So if there's something particularly important to you within Plymouth, you might go and speak to your MP, who might then raise that issue in Parliament. Now, running alongside the Houses of Commons in the red seats are the House of Lords. This is what the House of Lords looks like, and that's a little more interesting because you may not realise that they have 700 members, many of whom are unelected. Well, they're all unelected and unpaid, and attendance is voluntary. And of those 700 members, it's made up of a number of different groups of people. There are hereditary peers, and what I mean by hereditary peer is that of a lord whose the title, if you are the lord of so and so, you also automatically have a seat in the House of Lords, and when you die, your son, your daughter, whatever, takes over. Life peers are slightly different. They are people that have contributed to society or politics and are appointed to the House of Lords, and when they die, they lose their position. So examples of people who are life peers are people like Lord Sugar. So the guy off The Apprentice is a life peer and sits in the House of Lords. Sebastian Coe, who was an MP, was a long distance runner, ran the Olympics bid for Britain, is in the House of Lords. Andrew Lloyd Webber, the musician who writes musical, is a life peer. There are lots of them. And finally, of those 700 members, there are 26 bishops of the Church of England are members of the House of Lords. Now that's quite important to think about, because you've got 26 people there who have a say in how the country is run, coming from a specific religious background. So that reflects how our country is viewed as a Christian country. Many people are not so happy about this because they view that that is an unfair skew on how our laws are created. I'll let you make your own decisions on whether you think that is right or not. So what's the role of the House of Lords? Well, they are designed to complement the House of Commons. They will also scrutinise and amend legislation laws. They'll look at EU legislation. At the time of doing this PowerPoint, we're still in the EU. That will change as soon as we Brexit. They also will question the government. They'll debate policy issues and matters of general concern. They might also introduce some bills, and they also have the ability to delay legislation to allow further time for research and consultation. So they do have an important role. And finally, and this is a picture of the opening of Parliament, you can see here the Queen and Prince Philip, and what you notice is when Parliament is opened, actually that happens in the House of Lords, and all the Lords there are dressed in their fine regalia, and the House of Commons are invited to attend the House of Lords. So the Queen is the head of the whole of Parliament. If you think about the justice system, we refer in any court case to the Crown versus. So the laws of the land are effectively created by Parliament and then are rubber stamped by royalty, by the Queen, and therefore it is the Queen's law that is being enforced. Moving on. So what does the Crown do? Well, it opens each parliamentary session with a traditional ceremony, and if you Google opening of Parliament, you will see that. And every single law, all legislation cannot become a law unless it receives royal assent. In other words, unless the Queen signs it off. Now, in reality, the Queen doesn't have that much power. She rubber stamps any law that is made. Nevertheless, an act does not pass into law, does not become a law of the land unless the Queen has signed it off. The other responsibility of the Queen or King is to appoint and dismiss the Prime Minister. So when a Prime Minister wants to resign, they have to get permission from the Queen. When they want to form a government, they go to Buckingham Palace to get the approval of the Queen. Again, this is very much ceremonial. The Queen really can't do much to stop this happening. Nevertheless, that is how this country is run. So let's go through how we would get an act, a bill, a law through the Houses of Parliament. So when something moves from being an idea to actually becoming a law of this country. Now, it's important that you understand the different types of bills, and roughly speaking, they can be divided up into three specific categories. There are public bills, private bills, and hybrid bills. I'm going to explain these in a little more detail as we go through. And public bills can be split up between government bills and private member bills. Now, you'll need to know these different terminologies, and you'll need to know some examples, and I've given you some as we go through. The key thing to remember is during the process of something becoming a law, it starts off as a bill until it gets royal assent, in which case then it becomes a law. Okay, so let's have a look at these types of bills. So public bills are anything that affect the whole of the general public in England, Wales, Scotland or Northern Ireland. Okay, so some parliaments, such as Scottish, Welsh and Northern Ireland parliaments, do have the power to legislate on certain matters. Other bills affect the whole of the United Kingdom. So to give an example of this, if you are born in Scotland, you do not have to pay university tuition fees because the Scottish Parliament has made the decision not to charge students tuition fees. However, the English Parliament has decided to the contrary. I'm sorry to inform you of that. But to give an example of a public bill that encompasses all the general public would be a law, and here I've given you the example of the minimum wage. So if the minimum wage is set, that is what employers in the whole of the United Kingdom have to pay as a minimum to anyone that works for them, and that is law. So that's a public bill because it affects all of the general public. Government bills are bills that are introduced by the government. They usually are examples of honouring manifesto promises. When a general election comes about, each of the political parties will draw up a manifesto, which is basically outlining what they will do if you decide to elect them into power. Now, the example I've given is the Brexit bill. I think this is a good example to use. The Tory party were elected under David Cameron and then Boris Johnson with Theresa May in the middle to specifically, as a manifesto promise was, if you elect us, we will give you a vote on Brexit and we will honour whatever the country decides. That is exactly what happened. The country elected Brexit and then the Tory party worked hard to get us through Brexit. So that is an example of a government bill introduced by the government that will become law. Maybe when you're reading this or watching this presentation, that may well have happened. So there's an example of a government bill. Now, if we move on to private members' bills, these are bills or laws that are brought in by individual MPs who may have a specific cause that they are championing. In general, in any parliamentary session, not much time is allocated to deal with them, and actually not a lot of these become laws. However, what they do is they raise awareness of issues, and that does then perhaps lead to future legislation in later manifestos. It's also important to notice that these laws can be introduced by peers in the House of Lords. Now, the example I've given you of a private member's bill is the Sunbed Regulation Act of 2010. And that was brought in by a Labour MP, Julie Morgan, and in 2010 the Labour Party were in power. However, key thing being she felt very strongly that there was no legislation regarding sunbeds and tanning equipment. There was no age restriction on it. So basically anyone from 0 to 100 could go and pay for as many hours as they wanted on a sunbed. And she felt this was endangering children, people under the age of 18, and felt that it wasn't right that there weren't restrictions placed on this. And therefore this act came in 2010, and now in order to undergo commercial tanning, you want to go and get yourself ready for your holiday in Ibiza or Ayia Napa or wherever you're going, you now have to be 18 legally before you can go to a tanning salon. So it's thank tan for everyone that's under 18, I'm afraid, or out into the garden you must go. Private bills, that's the term that's used for any bill that affects specific individuals, organisations or areas. So it doesn't apply to the whole of the population, but to a specific group, organisation or area. They're very rare, and usually they come about because the individuals that want to change or want to have the private bill, or the organisation or the area, bring that bill to Parliament via their MP. Now, the example I've given you of this is the Southgate Cemetery Act. And this is basically Southgate Cemetery was filling up, not a lot of room left to bury people, so they asked in 2017 if they could have the rules changed for their specific ceremony that allowed them to double stack burials, one coffin on top of another, in order to save space. And that became a law in 2017. So the Southgate Cemetery Act is an example of a specific bill, a specific law that only refers to Southgate Cemetery and nowhere else in the country. A hybrid bill is a cross between a public and a private bill. Again, they're very rare. They tend to be introduced by government ministers, and again, they affect particular individuals, organisations and localities. And the example I've got is the high-speed rail bill. So the new high-speed rail link, that bill will affect all sorts of different people. So it'll affect the people where the railway line's going to go through. So it'll be, compulsory purchase of their houses or their areas of their gardens. It will affect things like protection orders on things like forests or wildlife. So it's a number of different individuals and organisations that are affected. So the bill is a hybrid. It meshes together all those different things. So that's what a hybrid bill is. Now, those are the different types of bill. The key thing I think for you, and this comes up frequently in the exam, is you really have to understand the process by which a bill becomes a law. And it's quite straightforward, but there's no two ways about it, guys. You've just got to learn it. So I'll set it out for you, and there's a couple of diagrams to come, and hopefully that will help you. Okay? So it always starts off with a green paper. The way I think about it is it's G for green, G for go. So in order to get the bill going, the government have to go with a green paper. And all the green paper is, it's a consultation process prior to setting out the bill, the law. Okay? So it outlines what they might do, what the options are, and invites people to comment. So to give you an example of that, if we were thinking in Plymouth Dock School of changing our school uniform, so we know we're going to change it, but we wouldn't just go, right, from now on, the colour of the school uniform is going to be bright green, all girls must wear trousers, all boys must wear trousers, everyone's got to wear this specific shirt. We're unlikely to do that, because if we just pass that law or that rule immediately, parents and students will be up in arms. So what you do is you would consult with the parents, you consult with students, get their opinions and go, well, we're thinking of doing this, would this be a good idea, what do you think? And that way the law, the policy, the rules are tweaked so that the public and people it affects are generally happy. So that's what the green paper is doing. It's setting out that first initial idea and inviting people to think, to make comments and think about some of the issues that might be raised if that law is going through. Once it's gone through the green paper stage, we move to the white paper, and that's when the bill, the law, is starting to sort of firm up a bit. So it's gone to the consultation stage, the green paper, and now it's sort of, you're getting sort of the nitty-gritty of what this bill, what this law is going to be about. Now, it's worth noting that sometimes a bill or a law can go straight to the white paper without the green paper, but in general it goes green paper, white paper. Once that's gone through, the government will then introduce the bill to Parliament. Okay? So it'll be introduced to Parliament, and the draft bill will be considered by a select or a joint committee. And a select committee or joint committee is a committee made up of MPs from different parties within the various houses. So this sets it out. So we start, here's the consultation with a green paper, which goes out for consultation. Let's think about what we want to do with this law. We've gone out to consultation, we've firmed up our ideas, we now produce a white paper which sets out what our policy is going to be. We draft the bill, the law, and this is the key bit. So what you notice here, there is an opportunity. The bill can start in either the House of Commons or the House of Lords. It doesn't matter where it starts, because no matter where it starts, it always has to go through both houses. Okay, so the process is the same. For the purpose of this, we're going to assume the draft bill has gone to the House of Commons. It goes to the House of Commons. There is a first reading, a second reading. It will then go to the Public Bill Committee, a third reading. And after the third reading, it will then move to the other house, the House of Lords, and the same process will happen again. First reading, second reading, committee stage, third reading. Once that has happened twice, both in the House of Commons and in House of Lords, it moves to royal assent. The Queen signs it off, and then basically it moves from commencement order to statutory instruments, and it becomes a law. So really, from your point of view, you just need to know green paper, white paper. either House of Commons or Lords, and then it goes first reading, second reading, committee stage, third reading, royal assent. Once it's gone through twice. So House of Commons, House of Lords, royal assent, or House of Lords, House of Commons, royal assent. I wouldn't worry too much about this section because basically once it's been signed with royal assent, it has become law. So let's go through this. Okay, so our first and second reading start in the House of Commons. First reading's a formality. At the second reading, MPs debate the main principles. In 2005, the Labour Party had plans to extend maternity leave. The Work and Families Bill had broad support at second reading, so the bill moved to the committee stage. Okay, without any opposition whatsoever. I missed out a bit at the bottom, but don't worry too much. You can look at that on the PowerPoint. If we go through a private members bill, MPs can introduce their own legislation in the form of a private members bill. So I've given the example of Julie Morgan with sunbeds, and she won government backing, and her bill moved to the committee stage, first and second reading. At the committee stage, all bills that pass the second reading are considered by a public bill committee. That's got to be at least 16 MPs, and the bill is gone through line by line, and that's when amendments come in. And they can also call experts to give evidence, and they may meet several times before returning the bill to the Commons. Now, in general, you'll notice here this little diagram, we've got blue for Conservative, red for Labour, and yellow for Lib Dem. This diagram was done when Labour were in power. So what you can see is the amount of MPs from each party that sit on the committee is generally in proportion to the amount of MPs that party has elected. So when Labour were in majority, the majority of people on a committee would be Labour MPs. Nevertheless, there would still be Conservative or Liberal Democrat members. In the current climate, you would expect to see more blues than reds. Simple as that. So it's very straightforward. In the report stage of third reading, further changes can be made, and at this point there could be a rebellion. Parts of the bill might be defeated by a vote, and this is what was happening with the Brexit bill when it was coming through. It was coming through and then it was getting kicked out at various readings. Okay, so it's by no means a foregone conclusion. When we get to the House of Lords, the same process is followed. So first reading, second reading, committee, third reading, to the next House, whether it's the House of Commons or the House of Lords, depending on where the bill started. And after that, as you know, we move to royal assent. Now, if you have a quick look here, hopefully this is going to work, this link will take you, I'll just change my pointer for a moment, hold on. Let's see if I can do that. Ooh, what's what I've done? I've got it on laser. Pointer options. I can't get that to work. Oh, yes, I can. No, I can't. So I do beg your pardon. Go back one spoke off. I can't go back, guys. If you click on that link, that will take you to various laws that are going through government at the moment, and you can see what stage they're at, which house they're in. It's a fairly obvious thing. Have a look at it, and you can have a look at that. Okay, so that outlines the setting of law. Green paper, white paper, starts off in the House of Commons, the House of Lords, first, second, committee, third reading, royal assent. You need to know it. But you also need to know the distinction between what is civil law and criminal law. Hopefully you'll have an idea of what this actually means. So let's do this in a little more detail. When we talk about civil law, what we're talking about here is any law that is concerned with the rights and duties of you as citizens in this country dealing with other citizens. So that's going to be stuff like lending and borrowing money, you know, how banks treat their customers. Entering into contracts, that would be things like buying a house, motor insurance, your mobile phone contract. that you have rights within those contracts. Law covers you, civil law covers you. It would also be disputes with neighbours. He's built his fence on my land. That is civil law. Getting married would be covered under civil law. At the same time, divorce, inheritance, wills will all be covered under civil law. Now, criminal law is much more straightforward. That's offences against society as a whole. So that's going to be stuff like crimes against the person, which would be, examples would be murder, assault and rape. Property crimes, which would be stuff like theft, burglary, fraud, and vandalism. And that's the different types of law. Now, as well as the lawmaking process of Parliament, it is also possible for laws to be set in another way. Now, a common mistake that's made in exams, you'll get a question that says, describe the lawmaking process in the United Kingdom. And candidates, students go off and they go, oh, that's brilliant. I remember my process. I can remember green paper, white paper, House of Commons, first reading, second reading, committee stage, third reading, then to the House of Lords, exactly the same process, and then royal assent. That's how a law is made in the United Kingdom. However, there is another way that laws are made, because it's not just the House of Commons that can make laws. Judges can also make laws, and it's really important that you understand how judges make laws and don't just think it's only done by the House of Commons. In general, the House of Commons are the people that make the majority of our laws. Nevertheless, judges can make laws, okay? So you need to be a bit clear on this. So just to give you some basic background on judges, judges are appointed. They're chosen by the Judicial Appointments Commission, which is an independent organisation. And in order to be a judge, you've got to have been a really experienced barrister or solicitor, okay? But that experience can level. And on this PowerPoint, I've given you a link to the JEC website, which you can find out more information on, but I'm not going to go into that today. And the idea is the judge will use their knowledge and experience of the law to make sure that a trial is conducted in a fair and legal way, okay? And this is also quite a common question in exam papers. Outline the role of a judge in a case. So the primary role of a judge is to actually ensure that the trial is conducted in a fair and legal way. However, okay, there's a little more nuance than that. Crown courts in England and Wales are where serious criminal cases are heard by judge and jury. In those cases, the judge is making decisions about the law and managing the trial. It's the jury that considers the evidence and decides whether the person on trial is guilty or innocent. Now that's really important, okay? In a Crown Court case, the role of the judge is not to decide whether the accused is innocent or guilty. That is the role of the jury. The role of the judge in a Crown Court, as well as ensuring that the case has been conducted fairly, is to pass sentence once the jury has found the defendant guilty or innocent. Okay, now that's absolutely key. Okay, because the sentences have got to be applied consistently. Okay, so the judge will issue the sentence. So to give you an example, if someone is found guilty of murder, the mandatory sentence in this country is life imprisonment. So a judge has to give life imprisonment to someone who is found guilty of murder. They cannot not give life imprisonment. The judge may decide, as well as giving life imprisonment, given the nature of the crime, that there is a minimum term that offender has to serve. So you could have a judge that says you're sentenced to life imprisonment and must serve a minimum term of 20 years. Or you could have someone that says life imprisonment with a minimum term of 10 years. So that is where the judges have a little bit of leeway. Okay? As well as that, throughout the trial, the judge will make sure the jury is aware of its legal role and what it should and shouldn't do, so that the court case stays within the law. In civil cases, it's a little different. They can be heard in high courts or county courts, but there's no jury there. So in a civil case, it's the judge that's listening to the evidence and to the arguments from both sides, and then the judge makes a decision. So in a civil case, the judge is acting as jury as well as judge, and that's an important distinction to be aware of. So let's say the judge is dealing with a divorce settlement. The judge might be encouraging cooperation between the two sides, or trying to control the way the case is handled, or help to settle the case, or suggest other ways of solving the problem. Judges will also hear family case, okay? So they can be heard in a high court, county court, or indeed a magistrate's court. Now, magistrate's courts are slightly different, and I'll be dealing with those in a different PowerPoint. But family cases can include divorce, child cases. This is an example of where the local authority might take a child into care. That would be a family case, okay? Or custody battles, private laws. Who gets custody of the children in a divorce? That's the sort of thing we're talking about in family cases. And again, in those situations, it's the judge that makes the decision. Okay. Again, in family cases, just a little bit of information. No juries. Quite often in family cases, the judges actually don't wear robes to make everyone at ease, and they'll hear different arguments or opinions from experts, and they'll think what's in the child's best interest. Okay, so it's fairly straightforward, fairly obvious. This is the key bit though, and this is how laws change. Because a law can change depending on how a judge interprets the law. And it's really important to understand that judges are independent from the police and government, and so the police and the government cannot tell the judge what to do. And also, judges can't have their decisions changed by a minister. Okay? So if a judge decrees that a law that has been brought about by Parliament is wrong or cannot be enforced, the government can't just say, well, we're disagreeing with the judge. The only way they can get that change, that judicial decision change, is to appeal to a higher court. And if they lose that appeal, the law stands. Okay? So the laws are created by Parliament, but it's the job of the judge to make sure that people are punished if they break those laws. Judges interpret the law by applying common law. And common law is the term that's used to describe the sort of way of doing things that's grown out of decisions by a judge in court cases over decades and centuries. Okay? So this is important because in order for there to be justice in the country, you've got to have fairness, which means that if I am tried for murder in a court in Plymouth, or a court in Hull, or a court in Edinburgh, or a court in London, if I have committed this, or 4 different people have committed virtually the same crime in 4 different places, will their sentence be the same? Because if there's inconsistency, then there isn't justice, and people could challenge that. Okay? So when a judge makes a decision, there's a ripple effect on that decision, and the higher courts down to the lower courts, and they've got to think about the decisions those judges have made to interpret how they make their decisions. And this is often done by lawyers. You may see in TV programmes lawyers citing cases where they go, well, in this case, Your Honour, the judge made this decision. We think the case we're trying at the moment is similar to this case, therefore you must do this, because the law must be the same in every single case. I hope that makes sense, okay? Because cases can't be random and punishments must be the same. So fairness is throughout, okay? So the key phrase that you have to get on board is judicial precedent, okay? Judicial precedent. You have to know it, okay? So this is a law made by judges in the court, okay? So when a case appears before them, a judge makes a judgment. This then forms a law, and therefore it must be followed in every similar case in the future. Now the example that is given in the textbook, and also is a good one to use, is the Donahue versus Stevenson case in 1932, where the judge, a ginger beer bottle was found to have a decomposing snail in it. Donahue and sued Stevenson, I think it was that way round, and the judge argued that this was negligent. The manufacturer of the ginger beer should have ensured that the process of making the ginger beer was such that decomposing snails didn't get in there, and they had a duty to ensure that was the case. Therefore, they were guilty of negligence, and therefore they received a fine, whatever they got. 6 years later, Daniels versus White, there was a bottle of lemonade which was found to have some metal in it, and in that case, all the lawyer did, the judge did, was go, well, 6 years earlier, in the case of Donahue versus Stevenson, the judge decided that this was negligence. This is a very similar case. Okay, it's not ginger beer, it's lemonade, it's not a snail, it's metal. Nevertheless, it's about stuff you wouldn't expect to find in a bottle of fizzy pop, in fizzy pop. Therefore, it is also negligence. So this is what's known as a judicial precedent. Once the judge has made a ruling in one case, it sets the law for every other case. And the reality is that precedents can only be overruled in a very senior court, and they're very, very unlikely ever to be overruled in reality. Okay? That is the way judges set laws, and there's one other way. So as well as judicial precedent, there is statutory interpretation. Okay? So this is where judges in superior courts, such as the Court of Appeal or Supreme Court, interpret the words or phrases within a law. And if they interpret words in a specific way, that can lead to laws being changed. Now, the example I would use is Whiteley versus Chappell in 1868, okay, where Whiteley was charged with the crime of impersonating a person entitled to vote. Now, what happened was, I think it was Whiteley, they took the voting slip of someone who was dead, okay, and voted as that dead person. So cast a vote, an extra vote, on behalf of someone who was dead. Okay. Now, the defendant argued that the law says the crime is impersonating a person entitled to vote. Now, the defendant argued, okay, the defendant had impersonated a person on the voters list, but the person had died. Now, if you are dead, you are no longer entitled to vote. You can't be entitled to vote because you're dead. Therefore, the person who was charged couldn't be found guilty of this crime because he was not impersonating a person who was entitled to vote, because the dead are not entitled to vote. Therefore, it's all about the wording of the law. The other example I could give you is there used to be on buses a sign that said no smoking allowed. And a person was taken to court because he was smoking on a bus, and the judge said, well, didn't you read the sign? And the guy said, yes, the sign said no smoking allowed, which means that I'm allowed not to smoke if I choose to, but also it doesn't say that I can't smoke. It just says no smoking is allowed. So it's by this way that laws are changed, where loopholes are found because the wording's wrong, and therefore judges will change wording to make laws achieve what they were meant to do in the first place. Okay? So I don't think anymore we've got a law that says it's wrong to impersonate the person entitled to vote. The wording would have been changed slightly. So that's statutory interpretation. Again, statute is another word for law. So statutory interpretation is interpretation of a statute or a law, the wording. Okay? Hopefully I've explained that well enough. Okay? So judge's sentence, when judge issues a sentence on a convicted criminal, they must work within guidelines set by the government. This process helps to make sure that sentences are fair. So what you might find is that the government might change a law. So for instance, dangerous driving or drug driving, what's gradually happened is the minimum sentence for that crime has increased as parliaments have changed the law. As soon as the law is changed, then the judges must uphold that law. So if the minimum sentence for drug driving suddenly becomes 4 years, then if you're sentenced for drunk driving, it's a 4-year minimum sentence, simple as that, and judges must uphold that.